Very good afternoon, everyone. Can you all hear me? Very good afternoon. Yes, just a very brief introduction about myself. I just mentioned that I'm a director of this law corporation, Subra TT Law LLC. We practice property, law, conveyancing, and all other areas. I think you've got my name card, the big and the small one, in the goodie bag, so you can keep in touch with me. Okay, one thing that I want to say is this. We do not have to anticipate many Friday evening shocks. You know, all the cooling measures and the announcements usually come on a Friday evening so that you can have a nice weekend. And it's almost always with almost immediate effect, right? With immediate effect. So like what was shared just now, the other countries are a bit slower in implementing change. We are super fast. Okay, now, I'm going to touch a little bit on the purchasers and the sellers' legal considerations when you buy and sell properties. Let me first start with the contract. Right? You've got the contract for sale and purchase. You've got the option to purchase and sale and purchase agreement. These are the two types of contracts that are used for sale and purchase of properties. Am I right? Yes. When do you use the option to purchase and when do you use the sale and purchase agreement? Do you have free choice? Let that be the start. Do you have free choice in choosing which contract you want to use? I'll say yes and a no. If you look at public housing, you have absolutely no choice because you have to use the option to purchase because the HDB Act says that you must use their option to purchase. And can you make any changes in the contract? Has anyone ever tried making changes, rewriting the contract, and then successfully buying and selling a HDB property? Anyone? Raise your hands. You need to stay back. I need to talk to you. How you could have possibly got that done? That will never be possible because you're buying and selling on the standard terms. So that's why it's called a standard HDB OTP. Yes. Now you look at a sale and a purchase from a developer who's selling a primary property. Yes. He issues the OTP when you pay your booking fee of 5%. And then they give you the sale and purchase agreement. Am I right? They give you what is known as a sale and purchase agreement. Even there, the contract is the sale and purchase agreement. So the law has prescribed. It means it's required by law. There's the Sale of Commercial Properties Act and the Sale of Residential Properties Act. And the rule says that must be so. And is that standard? Or can you talk terms with a developer? Can you tell the developer, I'm a very powerful buyer. You know, I'm a very powerful buyer. So can you give me better terms? My friend who is with me is not so clever. So give him less favorable terms. Can you try that? Can you do that with a developer? Can that happen? But it used to happen in the past, where developers had freedom. If someone looks not so clever, then they'll give them less favorable terms. This was actually a long time ago, you know that? So the law said that the buyers needed protection. The buyers needed protection. And therefore, it was standardized because developers don't have to bully. We have to look at this thing called dealing with arm's length. You know arm's length? Your arm and my arm are almost of the same length. Am I right? But if you take the HDB and the entire population, whose arm is longer? Definitely the HDB's arm is very long. And a developer who sells 600 units, I better be careful, man, at the age. A developer who sells 600 units. A developer, and all the buyers put together, who is actually a more powerful person? Certainly the developer. So the law says protection. Arm's length, they have different arm's length. Deep pocket, developers got a deeper pocket, it means more money. You and I have lesser money. Am I right? So for these reasons, there's uniformity, there's standardization. But if you look at a secondary property, you know, a completed property and you're buying from someone, the seller and the buyer only, then are you free to dictate your own terms in the option to purchase? Or you can call it a sale and purchase agreement. Nobody cares. These are the only two contracts. Then can you dictate your terms? Of course, you have absolute freedom here to dictate the terms that you want to. And this is going to be a little bit of point where I will highlight a little bit more. Because you have freedom. In the other areas, you don't have freedom. You have to take what you get. Okay? So, very often, you find that you will have to pay consideration. For property transactions, is consideration needed? Certainly yes. Definitely. Yes? But not for rental, Many people have told me that when it comes to a lease or rental, there must be payment of money. Rental must be paid. But actually, that need not be the case. There's no need for rental payment for there to be a landlord and tenant relationship. Because the definition for a lease says, usually in consideration of rent. Usually. Why would they want to use the word usually? Because there are situations when you don't need to pay rent. How is that possible? You are staying in one of the rooms in my apartment and you are doing accounts for me. You are providing me with some service. I've not spoken to you about rental. You have not done so. And you have actually become a tenant. So be careful. If you have someone doing accounts in your house, he's a tenant. Okay? Now moving on. So consideration is very necessary. Consideration, yes. And then basically a seller is selling on his terms. This is something very, very important, very fundamental. A seller sells on his terms. An option to purchase. What is the meaning of an option to purchase? It is a right given to a buyer to buy. An option to buy. The seller makes the offer and the buyer accepts. Do you understand? For there to be a contract, there must be an offer meeting acceptance. You agree? If acceptance does not meet, then it's one way, unilateral, an offer only made. Am I right? So when I make an offer, wouldn't I put in clauses which favor me? Because the sale is on the seller's terms. Is it natural? Of course. So when you are a buyer, if you are a buyer, and you make your 1% payment and you take the option from the seller, game over for you. You cannot ask the seller to relook at the contract or you request for changes to be made. We act for many buyers who come in and they say, oh, after taking a second look, I feel that this contract doesn't suit my needs and I would want many changes. And we tell them just one thing. We can always write to the seller. If he's a Mr. Extremely nice guy, he can give in to all your requests. But he does not need to. All he needs to say is a flat NO. Because the seller is selling on his terms. That's a price, and all the terms are as written in the contract. So what must you do? If you're a very careful buyer, before you part with any money, what should you logically do? You're happy with the price, you're happy with the property. What you next have to do is to ask the seller to give you the draft contract that he wants to use. You take the contract. If you want to, you can bring it to me for a small fee. Okay? Because it's just the start. Because you're just thinking about it. Because you've thought, well, we will give you a big discount. Because you've used your brains. So you come in and you tell us what you want and what you do not want. We'll take you through the option to see where things are in conflict. And then we'll make the changes. We'll make the necessary changes and send it back to the seller. The seller will look at it and he'll say, oh my God, I've got a careful buyer on the other side. And what does the seller do? He will straighten up and make more changes. So he'll make more changes and send the document back to the buyer. The buyer will look at it and say, oh my God, this guy is terrible. I have to be extra careful with this character. And then he makes some more changes. So they're all learning contract law and their own requirements. They're studying each other more than dealing. So the poor salesperson in between will have to wait. Because the contract is going to and fro. Actually, this is what's supposed to happen, but it doesn't happen. Why? Because many salespersons may tell you, hey, it's standard, come on. Standard, look at me. You know which company I come from? Excuse me. You know how many deals I've closed before? Excuse me. So you excuse yourself. Okay, I don't need to use my brains. You take a step back and you say, okay, I'll follow whatever you're saying. That should not be the case. When I talk to salespersons, I conduct continuing professional development training for them also in many real estate agencies and institutions. Some of them have asked me to come in, like full-time to do this, help them out. So I tell them, don't ever say it's standard when it's not supposed to be standard. When it's a HDB sale and purchase, it's standard. You better don't say you have flexibility. When a developer sells his property, that's also standard because the rule says, the Act says so. But not in the case of a secondary property. Wrong to say it's standard. Okay? So make all the changes you want to and then you keep going. But I tell you, when I'm talking to you about this, something's coming to my mind. I did a service provider contract, 40-page small print contract. The clients first came to me. It was only about this thick. By the time they signed the contract, the file became this big, which is good for me. Of course, I can bill. Because there's a lot of work done. That is supposed to be the case, and not just accepting whatever they ask you to accept. Am I right? Yeah. I realize some people will go to a property and they will melt, They'll say, oh my God, oh no. Finish, that's it. Then you're at the mercy of the seller. Negotiate when you have the chance. Don't lose the chance to negotiate. That's my point here, okay? Right. And then, of course, so I said, the seller makes an offer, the buyer pays consideration, and he has to exercise the option. Am I right? This is called the option expiry period. He's given a certain time to exercise the option, meaning to decide whether he wants to sell the property or not. Now, at this point, can a seller change his mind to sell the property to you after taking consideration from you and issuing the original signed option to purchase or sale and purchase agreement? He's given it to you, and now he says he's changed his mind because someone else has come paying another 200,000 more. So can he call you and say, hello, yeah, Mr. So-and-so, can you take your check back? And then he says, no. Can I send the check back to you? Both options are out. He says no again. Right? This is usually the case. Is there any law to this? Is there any legal explanation? Of course. Because at this point, there is in existence a unilateral contract, one-way contract, which binds the seller only. It does not bind the buyer. Because the buyer can choose whether to buy or not. Agree? Because he's got time. But the seller has made a unilateral one-way contract where he has said to the buyer, I will hold this, am I right, for this period. So he cannot deal with anyone else. It's too bad for him. Game over for him. Yes? But the buyer has a choice. The buyer, if he wants to buy the property, he has to exercise it within the option expiry period. Am I right? Yes. Now, how does he exercise? Usually, the exercise will be like this. You must make the balance payment and deliver the signed option. That means there will be a column called the acceptance copy. You understand now? Why it's called acceptance is because offer meets acceptance to form a contract. Got it? And then you deliver the document to the seller's lawyers. Okay, so this is exercise of an option. Question, how do you exercise the option? There will be a date given, the last date, right? And 4 p.m. is the cutoff time. 4 p.m. People are very strict with the time. Let me tell you this. 4 p.m. If you don't exercise by 4 p.m., that's it. I think the reason why they chose 4 p.m. is because it's si tiam. 4 p.m. Si tiam. Say. It can be 5 o'clock, but it's 4 o'clock. Don't ask me why it's 4. Okay? So by 4 p.m. How do you exercise the option? Sometimes mistakes have happened. I'll highlight this to you. It should not happen to you. This is very, very fatal. Not just for the buyer, for the lawyers also. You must have read in the papers. How does the seller want the option exercised? Very important. The sale is on his terms, and the law here is the buyer must exercise the option in strict compliance. What does that mean? What I say, the seller, what I say is what you will do, nothing else. For example, if the seller says, you make the balance payment and deliver the signed option by sending it by registered post. You heard me, huh? Registered post. And then I send my clerk, if I'm acting for a buyer, I send my clerk to deliver this document by hand. So the clerk goes knocking on the door of the law firm, seller's law firm. Knock, 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 and the door opens and he says, I'm here to exercise the option. Okay, I'm here to exercise the option. And they look at it and they say, I'm so sorry. It's now 3:45, let's say. Are they within time? Because it's not CTM yet, right? It's not time. So it's still within time. But they will say, sorry, there's no exercise of option. And then this clerk will flip. You say, why not? Oh, because it's supposed to be sent by registered post. And he says, come on, hey, look, which is better? Or get real. Look at me, I'm real. Look at the document, that's real. And it's real estate, come on, man. Get real, man, what else is left? So accept it. This is a more expeditious means of delivery. A better method, isn't it? Do you agree? Instead of sending it, you come and give by hand, and it can be rejected. Why? Because the seller wants it sent by registered post. Another case, this is called a fancy case. It's called a fancy case. There's a reason why it's called the fancy case, because I think they were trying to get a little fancy here. In this particular case, the seller wanted the balance payment, the 4%, to be made in the seller's favor. You understand now? Seller's favor. So it must be made out in the seller's name. But the buyer's lawyers advised the buyer to make out the option in the seller's law firm's name. And they exercised, and of course they rejected. They said, no, there's no exercise. And then they flipped and said, why not? Oh, because it's supposed to be in the seller's name. But come on, you're acting for the seller. And when I make this payment in your favor, the seller's law firm, you are to hold it for the seller. Am I right? Logically, it's not the law firm's money. Right? Is it a law firm's money? Or does it depend on the amount? We don't hear news of this happening for a long time. I hope it will stay like this. I get pressured when lawyers run away with their money. Because very often, there are other lawyers in my office who see the clients. And then on and off, I'll get a request, especially during the season when many of them were taking the monies and running away, scooting. And what's made it more easy now is because there's an airline called a Scoot. So what has happened is, they will say, can I see your boss? Then my lawyers will ask, why? I mean, I've explained everything to you. And they say, no, I just want to see him, just to have the comfort. And then I'll walk in with that innocent face. And then they would want to look at me. See, I got distracted. I joke too much now. What was I trying to say just now? Exercise of option. So it's got to be in absolute and strict compliance. You don't choose a better method. So they failed this argument. They went to court, They went to court for the court to declare on this. I made to the seller's law firm. That is for the seller. What is the big issue here? But the lawyers lost the case because the law here is strict compliance. What the seller says, you follow. So they lost the case. Okay, sometimes a heavy price is paid, 700,000 loss to law firms. This has happened before. So you can help, you can take note. When you are a buyer, you can inform the law firm. Please remember to make the payment to, because many a times we assume that it must be the seller's lawyer, very standard, to be sent by hand, usually. If they don't state, you can send by hand. But if they state a particular mode, you better follow that mode. Don't be creative. So that's my point here. And then what happens if you cannot exercise on time? What happens if you cannot exercise on time? If the exercise has not taken place on time, what happens now? Is it the end? Tell me. Is it the end of the whole matter? The seller can, of course, forfeit whatever you've paid. Am I right? Whatever monies you've paid up to now, the seller has the right to forfeit. Yes? Or he can choose to do something. So when there's no exercise, lawyers will, of course, advise their clients. The seller will call at about 4:10. Is there any exercise? And if the law firm says, if the lawyer says, no, there's no exercise, then what happens? It's already sitiam. Told you, right? So a seller can either forfeit and keep whatever monies have been paid up to now, or he can choose to do something. Sellers lawyers will say, you have two choices now. Choice number one is you can forfeit and there's no other deal. You can go on to remarket the property and sell to someone else. Option two is you can ask for money. So seller gets excited and says, really, can I ask for money? Can I make some more money? And the seller's lawyer says, yes, you can. Is that extortion? Is this extortion? Or some kind of ransom or something like that? It's not at all. Why? Because the law says, up to 4 p.m. that day, that was the terms of the sale. Am I right? The seller's terms. Because 4 p.m. is over, those terms are over. So if you want fresh terms, like allowing it to be exercised at 4:15 is a new term. So when you have new terms, there is need for fresh consideration. You understand now? Because there's need for fresh consideration, they can ask the other party to pay some money. You understand now? So normally sellers will sing this song. They will say to the buyer, you know, when I sold this property to you, I sold it at a very low price, that very low, the market has picked up now, are you reading or not, STProperty, I'm telling you, it's okay, all is not gone, I will accept, but you pay me 20K. And I know of some friends in practice who've gone through this, some of my friends, and they were readily making out checks, 20,000, 15,000, happily make out and pay. You know why? This is damage control. What if this person has lost the opportunity to buy and his loss now comes to 400,000 or 300,000? Beware. So it's better to pay 20,000 than to pay $200,000-300,000. That's one time lawyers will be very happy to pull out their own checkbook and sign. Because you don't have a choice. Okay? Right. Now, the other very important thing is this. If you look at your option, parties, price, property. These three things are very, very essential. Property, price, parties. Do you agree? Do you agree? The name of the parties must be right. Am I right? Sometimes I've seen documents where the surname is changed. Tan becomes Wong. Or the property address is wrong. Can you imagine? The property address is written wrongly. So whose house is being sold? Not your house, neighbor's house. Property address is written wrongly. Name is written wrongly. Price is written wrongly. Sometimes you have a situation where in words it will say 2 million, but in bracket, in figures, 1.5. So what do we do now? It becomes a bit uncertain. Am I right? And the law says that if a contract is so uncertain because the name is wrong, you don't know who is selling and buying, the property address is wrong, and the price is wrong, tell me, what else needs to go wrong? All that has to go wrong has gone wrong. And a court can declare that there's no contract because it's so basically wrong. Okay, that's the power the court has in deciding on this. So you can help. How can you help? I tell you how you can help. You give your salesperson a copy of your IC. Your address is there. They don't have to guess on the address, right? Your address is there, your name is spelled there, everything is there. So give them a copy, help them. Give them a copy of your IC. Okay. Right, the other thing is this, a very, very important thing is this. There are many buyers who do not do title search to determine if that person is the legal owner of a property. No title searches are done. But you will part with a lot of money. You buy a $5 million property, you'll pay 1% without doing a title search. Not advisable. Not advisable. Right? You do a title search because you want to know the legal owner. How do you know then who you're talking to at the property? A salesperson brings you, or you go directly, you walk directly into the house, and someone talks to you. How do you know that this someone is the owner? Do you ask? He just happens to be there and you start having a conversation with him. Right? You just start having a conversation with him. The owner could have passed away, expired. The son is in the property. And he tells you that, he doesn't tell you anything and you assume he's the owner and he keeps talking. And then he signs on a document, the option, and gives it to you and collects money, 1%. And then he disappears. You have to sue him to get your money back, am I right? Because who's this person? The proper administrator, executor could be another son, the eldest. Now the youngest is talking to you, so don't take risks like this. You're parting with money, right? Anyone can sign on an option and give you. Be very, very careful. Do a title search. And also physically inspect the property. Physically inspect a property. If you're buying a HDB property, you get a lot of help. Why? The technical officer comes, he walks around the house and he tells you what all needs to be rectified before completion. So you're protected. Am I right? Yes? If you buy a property from a developer, you also have got some help. Why? Because there's this thing called the defect liability period. From the time they give you notice to take possession, there's 12 months defect liability period. If there's anything wrong with the property, you just put it in writing and they have an obligation to do it for you. But in the case of a secondary property, most of the time what you see is what you get. So what do you see? How do you see? You know what I mean or not? If you just keep running into the property without looking at the ceiling, you know there are some people who view property like that, they're very desperate. From the outside they look and they say, wow, what a house. And then they start running inside, no? And they don't even look at the ceiling or the walls or anything cracks. No? There may be watermarks, a lot of watermarks on the ceiling, but no, they look at it and say, oh my God, wow, look at the dry kitchen, wet kitchen, look at this brand. Wow, women especially. The cooker hood and all that must be like Myla or, you know, the kind of well-known brand. Say, wow, this guy is really quality, man. But they never looked up because there may be watermark. So you must ask the seller, what's this? Seller says, watermark. And then the next obvious question is, why is there watermark? And a smart seller, phase one, will say, because there's water. And then do you just stop there? Ask him. Ask him, is it because of condensation? Because condensation to me is condemnation. Can I get my contractor to confirm? Yours to confirm? Any talk like this? No, nothing like that happens. Oh, water only. Oh, okay, water only. Good luck, water. It's at the right place. Right side of the house, feng shui. Dry season, no rain. So if you need water, ask. Is it an M&E problem? Mechanical, electrical problem? Or is waterproofing bad? Is there a bathroom up there? These are all the checks you have to do. Regardless of the Law Society's conditions, there's 1999 and 2012 version. 2012 offers a bit more protection, but you take the lead. You must be very, very careful in observing. Every house ends here, but this particular character's house goes, the dry kitchen is outside, or wet kitchen is outside. Why? Because he has taken state land. Of all land, he has taken state land. He is a real champion. And then you are very impressed. You know, when you walk into some houses, I've seen that in some houses. I cannot give you the address. Anyway, I walked into some houses and, you know, it just seems to end here. And after that, it's all very new. No? Have you seen? So it's only new to me. All of you are not reacting. When you walk into a house, you find, you know, the first part of the house looking a bit old. And then after that, you see like, wow, you can't believe that you are in the same house. So this can trigger you. What has actually happened? Why? Yes? And then, like I told you, what you see is what you get, but there are exceptions. For example, if there's some termite problem, must a seller inform you? Termite problem. Okay? Must the seller come to you and say, hey, buyer, you look like a very nice person. I've liked you the moment you stepped in. There's so many people who walked in, I never liked their face. But I somehow like your face. It looks good to me. And you say, you know what? Just go into the kitchen, just walk in, just see. Don't open any cupboard. Because I like you. Don't. So it gives a warning. Do you think a seller needs to tell you this because when you open, you find termites coming down? They don't need to tell you this. There's no duty. When will a duty arise? If the termite problem is so serious that it goes to the foundation of the property, then even if he doesn't say, you can get out of the contract. Or if there is deliberate concealment, you know what I mean by this, huh? I need to dramatize a bit. Let's say there is a hole here. There's a hole on the wall, okay? There's a hole. So you are viewing, you're coming into the property. Like after hearing a talk like this, you are very careful. And then you come to this corner and you touch the wall and you find it's very well plastered, very nice, smooth. And it also feels extra cool. You know, so on a hot day, you just place yourself like that. Wow, how nice. So you feel good for a while. Why you feel good? Because there's a metal plate against the wall, covering the big hole. So the law says, if there is deliberate concealment, you heard the word deliberate concealment, then you have a solution. But how are you going to prove that he deliberately concealed? Only God knows. Am I right? Some things are there, the law gives you a provision, but how are you going to prove that he deliberately concealed? So deliberate concealment is an exception. If a defect is so great that it goes to the foundation of the building, then of course, because then you're not buying the property anymore, no? It can drop anytime because termites infested, okay? Right. That's the Zane case that I'm telling you. Can you see? The Zane case, 1, 2, 3, 4, 5. Point number 5 about exercise. You better make it to the seller and not to the seller's law firm. This is the case. Fancy case, fancy. Right, like I told you, when you want to extend your option, it has to be supported by fresh consideration because the original offer has lapsed. You are now renegotiating. You're now renegotiating. Okay. Now, I'll tell you generally, fire risk is quite serious. You know, you've been reading reports about HDB flats getting on fire, some private apartments getting on fire. It's quite scary nowadays, you know. Because somebody came the other day and they said, there was this Caucasian lady, you know, she came to my office and she said, I don't know for what reason, there was a big fire. I said, where? She said, in an apartment. I said, where? She said, in an apartment. How did the fire take place? I don't know, for no reason, no, there's no one in the house. Quite scary, right? Could it be overloading or something? I'm not sure. I don't know. Reasons why fires are caught, just like that. The need for insurance, the duty is on you. Because there's this section in the Conveyancing and Law of Property Act which says that generally the position is, if the seller has insured, this is before completion, from contract till completion, you understand now? Because after completion, you are the buyer, you take the risk, am I right? So during this period, if there's fire, what happens? Can fire catch at any time? Does fire give notice? There's no notice period for fire, just like that, right? So fire can happen at any time. Between contract to completion, if there's fire, what happens? So this particular section says, if there is an insurance bought by the seller, vendor, then you can take it that it's for the benefit of the buyer. You heard what I said? All of you understand? But the Law of Societies Conditions 1999 and 2012 says that, but this section does not apply. What does that mean? The fire risk will pass to you, even before completion. So the Law of Societies Conditions says you can take over a fire policy from a seller before completion. You see, the law is very unique here. Can I insure your car and you insure my car? No way, because you must have proprietary interest. Am I right or not, for insurance? Am I right? But here, I'm not the owner yet. I'm not the legal owner yet. But I can take over your insurance. Two conditions. Number one, you ask the insurer for consent. Can I step into the shoes of the seller after a contract is formed? And I want to pay this amount of premium, and they will talk to you, and you can take over the policy. When you take a bank loan, the bank which pays the seller will also insure, will also buy insurance. Yes? For a certain period. After that, the onus is on you. What if there's someone who's paying all cash? See the point now? If you have a bank loan, then you've got the insurance, you can ride on it. But if you're buying it all cash, then the risk is on you because you've not initiated this move to get insurance. Okay, can a seller or buyer become a bankrupt after contract but before completion? These are things which can happen to anyone, right? After contract, before completion, seller or buyer becomes a bankrupt. What happens? What happens when someone becomes a bankrupt? What happens when someone becomes a bankrupt? Some people say he's got no future. That's not what I'm asking. What happens when someone becomes a bankrupt? The official assignee steps in. Because all his financial, especially financial interests, will now vest or settle in the official assignee's name. Title search will still show the bankrupt as the owner. Got it? But by operation of law, that means without you and me knowing, the law operates in mysterious ways. By operation of law, the property will vest in the official assignee. So who calls the shots now for sale or purchase? The official assignee. If your sale price is very good, above market, fantastic price, official assignee will be happy to say, proceed. Why? Because the official assignee's job is to protect the creditors of the bankrupt. The official assignee does social work. You know why? Because they are not so bothered about the bankrupt, but about the bankrupt's creditors. One can sing, but 20 people must be saved. Am I right? Logical. That's the reason why the law works this way. So his job is to save the creditors. Okay? So, if the price is good, he will say, yes, sell. Because why? The proceeds can be used to pay the creditors. If the price is low, what if the price is low? Maybe this person knew that it's going to become a bankrupt. Yes? So make a quick sale at whatever price, undervalue, and run. Right? So in this case, what will happen now is the official assignee will say, sorry, no sale to the buyer. And then what does the buyer do? The buyer cannot sue the official assignee for making this decision because official assignee is there to save the 20 other people. The buyer will have to make a claim against the bankrupt by filing a proof of that. Whatever losses he sustains, he just files with the official assignee and wait. And wait. And wait. Maybe in this lifetime he won't realize any monies. If he's lucky, one day he'll get a call from the official assignee who will say, there's some monies to be paid out and we want to prorate and pay, then you'll run. But I've seen cases where people have filed proof of debt through us in my office against a bankrupt, and one day they get a call, they're very happy, to come and collect some money. Because they may be selling their property. You have a duty to keep the official assignee updated, informed about all your financial affairs. The duty is on a bankrupt without the official assignee asking. It's an offense if they don't. Yes? Okay, so for a purchaser, it's the same. If a purchaser becomes a bankrupt, the official assignee can decide whether to go on with the purchase or not. Okay? And the documents for the transactions are all signed. The legal documents are all signed from this point, once he's made a bankrupt, by the official assignee. We have sent documents to the OA's office for them to sign on a transfer to complete the sale of the property. Okay? Yes. Okay, what if someone dies? Now we talk about someone becoming a bankrupt. What if someone dies? The buyer or seller dies before completion. Can happen, right? People can die at any time. So after contract, before completion, the seller buyer expires. What happens? What happens? The estate can step in. Law Societies Conditions 2012 says the estate, meaning the executor, if a will was made, it's called an executor. If no will was made, it's called an administrator. This person can now come and step into the shoes. We do all this in my office as well, estate matters. So this person comes to perfect the transaction. It's always possible for, time's up? Really? Tea break. Should I stop? Now that I'm on heat. I took some time to be on heat. Okay, maybe just a few more minutes, huh? Okay? See, I forgot what I wanted to say. Talking about leak, there's a water droplet that just came down. Oh my God, things are getting very real. Death. Personal representative steps in. What happens, the law says, personal representative can step in. Now, it will take time to get your grant of probate or letters of administration with lawyers. It will take a bit of time. It's plus minus 3 months. You understand now? For the paperwork to be done. To get this person to be authorized to sign and to deal with the buyer or seller. Now, During this period, the completion will be postponed for 3 months. You understand now? And the other party to the transaction, the other party cannot claim interest because you're completing late. They cannot. Do you understand? So this 3 months is the leeway for you to get this paperwork done and then to complete the matter. Okay, now the other thing I'll tell you is this. Let me just sum up the Law Society's conditions 2012. I was telling you, I was emphasizing a lot on what you see is what you get, right? Now, 1999 Law Society's conditions tells you that what you see is what you get, no matter what. What you see is what you've got. It's a bit disadvantageous for a buyer, am I right? But it favors the seller. But 2012 gives buyers some protection. Like, for example, if I'm a seller of a property, and if I had carried out unauthorized works without the approval, right, of the BCA, for example, if I had carried out works, then if you're a buyer, you come into the property, I have a duty to tell you that all these works are unauthorized. I must let you know beforehand so that you are warned. Okay? I must let you know. There is a duty to inform. If not, I'm in the wrong. So the law gives buyers protection. Okay? Right. Okay, maybe I'll say this about Malaysian properties, since there was so much of talk about Malaysian properties. Let me just touch on this point. Singapore's law is different from Malaysia's. Here you have to negotiate first and then sign the contract, right? But in Malaysia, you can pay your consideration. You can pay your consideration to the agent. The agent will hold it. In Singapore, agents cannot touch money. If they touch your money, they hold it, they have committed an offense. Because they cannot hold transaction monies. But in Malaysia, they can hold these monies. And when they hold these monies, what actually happens is this, What is the point I was trying to say just now? Okay, very important. After this point, after the consideration is paid, the lawyers will then start to negotiate for their clients. You understand now? Initially, no, nothing is signed. You just pay the deposit. Okay, the money, 1% or whatever, is given to the agent. And then the lawyers will be notified that there's going to be a transaction, and both the lawyers will negotiate. I can tell you something. You know what happens when lawyers start negotiating, right? If ordinary persons negotiate, what will happen? It will take a bit of time. When two lawyers sit down and start on a negotiating process, goodbye and see you again. It may take some time, but that's a law there. They allow. But the good side is negotiations can continue. And if there's a breakdown, then there's no deal, There's no deal. That is a good side to it. But of course, the other side here is we want a more robust, I think because we have a more robust property market, right? The whole world knows that it's a very, very robust property market here. You can buy and sell within quick time, and you can realize your profits. But of course, it used to be a lot faster last time. Now it's a lot slower, because we put all the cooling measures in place, and they have taken effect. Okay? With that, there'll be many more opportunities to share. My contact details are actually here. You may want to save this. Just this is very important, no? Extremely important. This is extremely important. Just a minute, Just bear with me. Yes, you see that here. You see, this is very important. This is the most important slide. You know why? I'm spending my Sunday with you here, no? But thanks to ST Property for all the advertisement given. Thank you very much. Keep in touch. Save the details. Don't lose it. Thank you.